Welcome to Channel AMEC, your insight to the Australian visa system. Good day everyone, my name is Carl Young, your online YouTube visa consultant. Are you interested about migrate to Australia? Why don't you consider to subscribe to our channel and turn on a little bell on the side so once we have all the updates and news, you'll be the first one of getting all the insights. Alright, now this video I will pay attention to what we call Schedule 3 requirement. Now, what does that all mean? It's predominantly happen for partner visa when you lodge onshore, where at the time of your visa application you did not hold the substantial visa status. So it's for people who were on a bridge visa, who are on any type of or any sort of status that is not really normal. However, the law does require and allows a visa applicant to actually lodge it based for the as long as you prove that your partner is an Australian citizen or Australian permanent resident. But there is also a criteria there for it to be waived. Let's jump into it, have a look. Now, you may be familiar with subclass 820 partner visa, which I've done a specific video for this type of visa. It's basically for Australian citizen or Australian permanent resident as a sponsor who are sponsoring his or her partner or spouse to be having the visa in Australia. So generally it's a relationship type or marriage type of stuff. But they are people, the applicants, who during the process of getting their lawful status of visa in Australia, they were pending on something, or they were waiting on something, or they were on a judicial review, they were on a merit review, or perhaps they have lost or forgot about renewing their visa, so their status is unknown or so-called unlawful, but the law still require and allow them to actually lodge it. Then they will require to meet what we call Schedule 3 requirements. So let's jump into it and have a look what it is. So if we go into the actual legal stuff, the law itself. Now let's see whether the wording is not too little. Okay, I believe everybody can see this. Now if you read on the regulation 820.211, which is basically the clause that's a part that requires you to demonstrate that your validity and your lawfulness in Australia. So it basically says if you're on a transit visa, you cannot lodge it, and you have to be a spouse or partner of Australians, and you have to be above 18. And at the end here, you will see that you're required to satisfy Schedule 3 criterion 3001, 3002, 303, 3004. And what does all that mean? That's basically, let me give a general explanations. Basically, for the sake and the rights not to break apart an potential Australian family, the law does permit and allows Australian citizens or Australian permanent resident to sponsor their spouse anyhow, whatever the status their spouse or partner is. That's just for the sake of the Australian partners side, because they are basically they are Australians. Okay, they need to protect the Australian families. Okay, but the Schedule 3 basically came out as to discourage people to actually utilize this part of advantage and taking advantage of the system. That means if I come to Australia, if one person comes to Australia and knew about this, they may not even trying to renew or apply for their lawful status with the visa. They stay unlawful. They do all the unnecessary stuff. Just for the sake of finding a new Australian partner or sponsor to marry with, so they can get their legal status renewed. So they're here to, the Schedule 3 is there to actually prevent this kind of stuff. And also, although it encourages or allows and permits people to do that, but it doesn't not want people to abuse the right of doing so. So let's get into the actual policy, what it actually reads. I think this will be very, very useful for a lot of people, because I do get a lot of inquiries about this. Obviously, they didn't. A lot of these people did not intended or planned to do this, but when circumstances does come. Okay, so you can see that you can read here immigration status, and it's all about A20.211. Now, you may notice it doesn't apply to 309, which is the offshore application for partner visa. Now, of course, because if it's offshore, you don't have that problem there, because you're not in Australia. You're not required to, redeem your lawfulness or status in Australia. So you don't need to do that. So it's only applied to 820. So 820.211 basically says here, it's only limited provision on unlawful non-citizen. That means people are not holding the right visa or not even holding a visa at all. Okay, and they apply for A20 visa. So it relates to these people, but no longer diplomatic or sofa. It's not sofa. It's not the couch that you're thinking about. Anyway, status and blah blah blah. So let's have read. Okay. So if a formal special purpose visa holder apply for a person, this is what SOFA is actually stands for. So the special purpose visa holder, it's actually going through ministerial intervention, and they giving them a special visa. So I'm not going to cover that. That's too deep to go into there. But let's read from 8.4. If a visa has been cancelled. So if someone has their visa cancelled, but then they were in a relationship with Australians, it's very different. Then they are allowed to actually apply for A20 partner visa, but because it's cancelled, they lost the accreditations and no longer being the lawful status. Then they will require to meet the Schedule 3 requirement. And they were a former diplomatic visa holder. Now that's a different one. It's not many people will have this kind of visa. This is for relevant government doings for U.S. Armed Force and things like that. So I'm not going to go into that because it's just too distinguished. So generally, people will for themselves here other unlawful non-citizens. Okay, you need to meet a compelling reason provision in order for the minister or the delegated minister to actually waive the Schedule 3 requirement, meaning that they will be proof. Otherwise, the visa will be refused. So if somebody just abused the law and come to Australia and did not renew their visa, they become unlawful, and they found somebody on a pub or bar and then fell into a relationship. 6 months later, they lodge a partner visa. Now, it's likely that the visa will not go through. Okay, you need to prove that the relationship has been there and it's genuine, and it's there long before things happen. So in doing so, however, officers should be mindful the intent to waive the provision is to allow people to circumstances genuinely compelling regularize the status. The provision are not intended to give or perceive to give or unfair advantage of person who fail to comply their visa conditions, deliberately manipulate the circumstances, and they can leave Australia to apply for partner visa outside. So that's the three major point that the Schedule 3 requirement is trying to prevent. So they want people to do the right thing rather than doing the wrong thing. But again, having people leave Australia, that's very it's debatable. If they leave, that means the potential of Australian families being break apart. Should they allow that? Should the Australian sponsor lodging a visa and then suffer on that one? That's really, it's a pros and cons. Anyway, let's read on. Examples where circumstances not to be compelling to waive is whether applicant remain unlawful number of years. So they've been in Australia a number of years unlawful, no visa status, and made little or no effort to regularize their status by claiming compelling circumstances on basis of long-term relationship. So that would not suffice the requirement. That means you're intended, you know that you're unlawful, and you have not done anything to actually get yourself back with a right visa. And all you want is to wait in for a long-term relationship and enlarge your visa. Now, it's really debatable unless the relationship there has actually produced a family with Australian kids. Now that's a different story. Okay, that's a different story. However, if you do wish to have a kids, you wouldn't wait for long years. Well, because when you have baby, you get yourself registered, in hospital, with the doctors, to access Medicare. So you wouldn't do that anyway. But some people would have done that. A lot of these people will have no kids there. Now, with the intent waiver provision in mind, generally reasonable expect compelling reason to exercise waiver provision exists where applicant circumstances happen beyond their control. Now, this is a good key point. Now, for example, I've got clients this year and last year. Now, obviously, we know what happened with the pandemic. They cannot travel. They cannot leave Australia. There's or even the international restrictions overseas. They are not allowed to go, or they are not allowed to come back. Now that would trigger a major issue on the relationships and the potential Australian families. So that's something that's beyond their control. That's one of the example there. This is circumstances beyond applicants' control had let them become unlawful or prevent them from regularize their status. Okay, for example, in scenario given earlier, it is reasonable to accept compelling circumstances exist to waive the Schedule 3 criteria if the reason beyond applicant's control, such as severe illness or incapacity. So rather than be a fit, healthy person and you never look to regularize, get your visa, then that won't be acceptable. But if you are ill, accident and things like that, not allowing you to move and to actually get your visa in time. But that kind of things will not likely happen, because if you're ill and severe illness or incapacities, there is a certain medical visa for you to actually extend yourself anyway. And the applicant will prevent to regularize their status in a year have been unlawful. So, in general rules, existence of a genuine spouse and de facto relationship between applicant and sponsoring partner, and or the hardship suffered from the separation of the applicant were to leave to apply visa outside Australia are not in themselves compelling reason to not to apply for Schedule 3 criteria. This is because a genuine relationship forms the basis of all partner visa and hardship cause of separation. So that means to simply argue that breakaway and the sponsor cannot travel and things like that would not be acceptable. But there are other points require to be demonstrated. For example, if you're in a same-sex relationship, okay, and some countries discriminate against such relationships, then that could be another reason. Obviously, that's beyond their control. Okay, and if they were to travel offshore and have such relationship and lodge a visa, they will be heavily discriminated against. And that's another thing that can be raised to waive the Schedule 3 criteria. Policy intended waiver provision should not be applied where it is reasonable to expect applicant to leave Australia to apply outside Australia partner visa. It's not only ensure fairness and equity to other applicant, discourage deliberate non-compliance. That's the key, deliberate non-compliance. They don't want to encourage people to not comply with the visa, but also preserve the integrity of partner visa program in general waiver provision in specific matter that officer should take in consideration whether applicant circumstances may consider compelling, include not limited to. All right, let's have a look. What are the compelling reasons? There are 5 examples here. So any history of non-compliance by the applicant. So if they have complied their visa or not. Okay, a lot of people may have their visa refused or rejected or cancelled. Make sure you go through a merit review, judicial review. So that's all the procedures to actually regularize your visa status, rather than just sitting there and not doing anything. That's the wrong thing. Okay, the length of the applicant being unlawful. That's again, if someone, let's compare one person forgot about the renewal of the visa for about 5-6 months, and then found out no longer visa valid, but he or she has a Australian sponsor and partner and been in a relationship for at least 2 or 3 years. Then they lodge a partner visa, then that's fine. That's just overlook, forgot about the visa. But if someone who has been unlawful with no visa for 3 to 5 years, now that's a different story. Now, obviously, for a reasonable person, you will not forget something for 3 to 5 years, especially you're in a country that that you are not a citizen of that country. Now, that's something that's not acceptable. Okay, the reason why applicant became unlawful. So they'll look into how the applicant become unlawful. Okay, sometimes they forgot because they were in a heavy examination. Whatever the project, they've been too busy, accident, things like that. Okay, the reason why applicant did not seek regularize their status sooner. Okay, they need to explain all this. Why didn't you do it? Why didn't you do it? You may found it. You need to make a statement to detail out all these 5 points. Okay, what step if applicant had taken regularized their status? Okay, so these are all required to be explained. Then the delegate or the minister itself or case officer, immigration officer, will take this into consideration to actually waive the actual Schedule 3 criteria. That's where 8.8 will actually be. So what I'm trying to say here is immigration officer is not a bad guy. They wanted to help you, right? They wanted to help you, but the helping, the law that were intended to help the Australian or potential Australian families does not want to be misguided or become a way for people to abuse and to utilize in order to stay in Australia. So these are the Schedule 3 criteria and requirement. It's very commonly being met, and a lot of people just overlooked. They forget about it. They thought they had an Australian sponsor. As long as the relationship is there, it's fine. Everything will be fine. But sometimes it's not as easy as it is. Anyhow, do you have any friend who's like this kind of situation? More than welcome to leave a comment right down below, and I see you next video. Goodbye.